My name is Jason Steinberg. This is Miss Milo. And I'd venture to say you guys are all in for a real treat today.
And then we'll have the lunch dinner.
Yeah. Miss Milo and I happen to be two of the sharp... Oh, hold on for a second. Made a mistake. Miss Milo and I happen to be the two sharpest cookies that Ladle has to offer. So this is a real honor for you. I was told to consider opening with a joke. Alright. We're here today to give you some ideas how to practically approach reasonable services contests. And before we get into the training, we just want to emphasize there's not one right way to do this. There's plenty of wrong ways to do it, and there's plenty of right ways to do it. So take what you want from the training and discard the rest. If you have some great ideas, by all means use them. But the idea today is to give you some ways to approach these contests that can and should make your lives easier. So let's discuss some basics first. A parent has been granted family reunification services. What is DCFS's job? And essentially what the court is saying is, hey, DCFS, this parent needs some help. I, the court, want to be reasonably sure that when I send this child home, the child is not going to be seriously injured if we put her back with the parent. So can you, DCFS, make a good faith effort to help this family? And in order for DCFS to do that, their first job is to figure out what's wrong. If they didn't figure out what's wrong, they can't tailor a case plan adequately, and you might have a basis for a reasonable services contest. So let me give you an example. We have a drug case. And the petition comes in and alleges that the parent has a substance abuse problem, a drug program is ordered, and yet when we come to the 21E, 22, 21F, we see that the report discusses a whole lot of anger issues on behalf of our client. It says, yes, our client completed the drug program, but they're causing problems with the caretaker, they're being unreasonable with the social worker, they're getting in fights with so-and-so. Well, we might have a contest there to say, DCFS did not adequately address the problems. How long have they known about these issues, and why haven't they done anything to address them? So were DCFS's efforts reasonable in this case? The cases have told us that the record needs to show that DCFS identified the problems in this family, offered help to fix those problems, maintained reasonable contact with the parent, and made reasonable efforts to assist the parent. So when you are going through the reports and the Title 20s, you need to be looking for those four things. If one of those things is missing, that's what we're going to focus our emphasis on. We're going to disregard everything else that doesn't suit our purposes. And we're going to focus on bringing to the court's attention what we think they did wrong. So this goes into our next slide. It isn't our job in a contest, in any contest, to discuss or especially cross-examine a worker or question a witness on every single fact or issue that might be contained in the report. What we're trying to do is we're combing through the reports, and we're trying to produce a simple narrative to explain to the court why we're entitled to a favorable result. You want to think about yourself telling a friend about the case, okay? And we'll assume for this example that your friend is a reasonable person. Don't tell your unreasonable friend. We're talking about your reasonable friend, okay? So you're telling them, you're saying, hey, I got this case. The social worker, she's supposed to help the family. She only met with my client 4 times. Your friend's eating her salad. She doesn't really say anything. And then you say, you know, and she's got these intellectual disabilities. She's mentally disabled. They told her to take this parenting class that would help her. She took the parenting class, but they're saying she didn't learn enough from that parenting class. That she didn't get the innate needs needed in order to parent this child. And your friend looks up from their side and they go, that's messed up. That's what we're trying to get the court to do. We're focusing, we're pulling out and emphasizing the facts that support our theory, and we're discarding the rest. We want to emphasize those facts that get the court to look up from their whatever they're doing and go, that's messed up. That's how we win these contests.
Okay. And just if anyone's following along in their PowerPoint, we actually swapped the presentation, so flip towards the back of your PowerPoint, and then you'll kind of catch up with where our slides are in the presentation. Okay, so going off of what Jason was saying, typically your reasonable service contest is going to revolve around 3 general themes. The first being that DCFS did not adequately identify the problems leading to the child being removed from the parents and offer services designed to remedy those problems. So kind of what he was saying. Well, they say that the parenting class isn't enough. Did the department ever file anything or request that the court amend those orders, order a different parenting class, order a more interactive parenting class, play therapy, something like that that has to do with their issue? And our argument should always be that no, they did not. The second theme would be that DCFS did not adequately maintain reasonable contact with the parents. This is very important, and I'm sure that you guys have all had experiences with your clients. Well, the social worker didn't call me, and they want to tell you everything that the social worker did wrong. They're not returning my calls. I haven't heard from them the entire time. These are big issues for our clients, and they're very real issues. Getting in touch with the social workers is a very real problem. It doesn't only impact whether or not they're getting referrals to programs, it impacts their visits. And that goes straight to reunifying. So it's very important that DCFS maintain reasonable contact. And if they don't, it's our job to point that out to the court and make it an issue that they did not. The third would be that they made reasonable efforts. So I'm sure you've all heard clients say, well, they gave me a packet of referrals, or sometimes you might even see the packet of referrals that the parents signed that they received those packet of referrals. I would dare you all to call 5 of the numbers on that referral packet and see how long you're put on a waiting list for. This is very common, and merely handing a client a packet of referrals for parenting classes or counseling or something like that, also we want to let the court know that that's not reasonable. Just doing that is not reasonable services. Really, when you're basing your theory, you want to, similar to what Jason was saying, you want the court to feel bad for your client. You want your friend eating their salad to feel like there's some injustice that's being done to your client. That's how you win these reasonable services contests. Make sure you focus the court on the issues. County council will focus the court on everything that the parents didn't do. That is not what this contest is for. We're not addressing whether or not the client completed their case plan. Presumably, if you're having this contest, they didn't, and that's our whole argument. They didn't do this because DCFS didn't do what they're required to do. It's not what the parent could or should have done. That's not the issue, and the county and even minors council may try and confuse the court and say that that's the issue. Well, you know, we gave the parent the referrals. We handed them the packet of referrals when we first met with them during that first month of reunification services, and that's our reasonable services. It's not our fault that they didn't, you know, use those referrals. That's not the issue. You can and should blame your client's lack of compliance on DCFS's failure to provide reasonable services. The focus needs to always be on what DCFS did wrong. It's very easy for the court to get sidetracked and say, I see it a lot with incarcerated parents. Well, that program's not available at their thing. It's not what the parents didn't do, it's what DCFS didn't do. It's not the other issue that sometimes the county will assert. Well, there's not a substantial likelihood if we offer further reunification services that the child will be returned at the further date. That's also not the issue. And how we put on these contests. So our weapon is the Title 20s. I assume everybody's familiar with Title 20s. If you don't know what Title 20s are, make sure you reserve that question until after the presentation and we'll explain that. Title 20s are essential to your theory and your case that you're making to the judge. They help you identify the facts to highlight. So it's very important that you know these inside and out. They almost always contain sparse contacts between our client and DCFS. I'm sure you guys have looked through Title 20s. It'll have, 10 contacts in a month with the caregiver and the social worker, or the child and the social worker. But if you look for your client's name up in that participant section, it's much more rare. Okay, so now how do we use the Title 20s? And we're trying to give you guys practical tips. So these are things that Jason and I use to prepare for contests. So, modify it as you guys see fit. We're just trying to give you some tools. So you want to compile a list of all the references. So as soon as you get those Title 20s, and just so you know, when you're setting a contest for reasonable services, make sure you ask for the Title 20s. Some people just ask for it for the last review period. Make sure that you know all of the contacts since FR was ordered by the court. And then what you want to do is go through, highlight every time DCFS contacted your parent. It's easiest if you make a table, and you can just put the date, what the contact was, like a brief summary. Oh, they called them. Did they answer? Was there any contact? They went out for an in-person visit. Did they actually meet with the client? Was anything discussed? And then do those contacts or the lack of contacts support your theory? So obviously if you read the Title 20s and you feel as the parents' counsel, oh, well, maybe the social worker did do what they were supposed to, then clearly that will change how you proceed and possibly withdrawing the contest. But it's very important that you look through these and you know it. Do the contacts match up with the report? So I'm sure you've all seen, you'll get a report, it'll say they have all these issues with the parents and their compliance, and then you match up with the Title 20s and you look and you say, well, during that month they had 2 phone calls with my client. In those summaries, those are supposed to be the entirety of the contact. Why on this phone call on such and such date, during the same time period these parents DCFS is saying these parents aren't doing anything, why aren't they raising this as an issue? Why aren't they saying that your parenting program isn't sufficient? You need to know better than anyone what's in those Title 20s. I can't stress this to you enough. The county knows every single thing in those Title 20s. Their social worker will come to court, they'll tell them everything. So it's very, very important that you're not missing things or skimming or anything like that. You have to know what's inside of those.
So actually putting on your contest, so you've decided to call the worker. Anytime you're thinking about questioning a witness in any contest, not just the social worker, you got to give some substantial thought as to why I am calling this person. Like, what is my goal? Your goal is not to just ask a bunch of questions and hope that you get something that you could use in a closing argument. Your goal has to align with your theory of the case, and your point of questioning the witness is to emphasize those facts that help your theory. So in assessing this, you have to give some thought as to what's my best case scenario here. And it has to be reasonable. The worker's not going to get up there and say, yes, you're right, I now see the light since you've done some wonderful questions that I should have done way more than I actually did, and I agree with you, my efforts were not reasonable. That's not going to happen, okay? So what we're trying to do, though, is in our pointed questions, we're going to emphasize those facts so that we can later argue to the court that fact. You want to give some thought as to what your worst case scenario is, okay? And usually what that is that the worker brings a whole bunch of new facts and evidence that I wasn't aware of to disprove my theory. How am I more likely to achieve my best case scenario versus my worst case scenario? And how I'm able to do that is, one, through preparation, okay, knowing the file, knowing the context, and knowing the case, and knowing the Title 20s. But two, it's pointed leading questions that are to achieve a certain purpose. It's not just calling the worker and asking them a bunch of questions and hoping to get something that you might be able to use. So you have a plan of attack how you're going to achieve your goal. Have I anticipated problem areas in my response? So I'll just tell you what I like to do. I don't usually write out my questions, but I do, and some people may, and that may suit you and may feel more comfortable with that. What I usually do is I just give a lot of thought, and I play it in my mind, or I do it out loud as to what questions I'm going to ask. And then I also anticipate like what their responses might be. And so that allows me to be flexible and to have some ideas as to, okay, if I don't get the answer that I'm expecting or that I want, what am I gonna do next? Like how am I gonna steer it where I want it to go? But however you want to do it is fine, but I just think that you should give some thought as to not only anticipating the questions I'm going to ask, but the responses I might get and how I'm going to handle those. All right, so in a second we're going to tell you, we're going to show you, excuse me, how to lock a social worker into the Title 20s, which we've already, Ms. Milo told you, and you've all experienced, are usually pretty inadequate, pretty sparse, and they're usually your best evidence in a case as to why reasonable services were not provided. But let's just talk about cross-examination just briefly, real quickly. So cross-examination, as you've heard before, it's about control, right? You should be the one doing the talking, 90% of the talking. The way you do that is through leading questions, okay? Where things kind of get usually spiraled out of control is when your questions get longer and longer and more convoluted, and you want to be generally one fact per question.
Excuse me, Jason. Ms. Milo is getting rave reviews from Lancaster. They can hear you. When you turn and face the screen, they can't hear anything you're saying.
Okay.
Thank you.
I'm going to move it over here because I kind of...
You could even hold it. I don't think they'd mind.
So, generally one fact per question, right? Like things get messed up, and you tend to open the door for the worker to give you a whole bunch of stuff that you don't want, or a witness in general. The longer your questions tend to be, you want to be pointed in your questions. You sent the parent referrals, correct? You sent them on this day, correct? Okay? That way you don't get a bunch of nonsense answers. And if you do get a bunch of nonsense answers, you can obviously object, non-responsive, or you can refocus the witness. I asked you whether or not you sent referrals to the parent. You told me 27 other things unrelated to that. Let me ask you again. You sent referrals to the parent, correct? Just because it's cross-examination doesn't mean it needs to be, you don't need to be hostile or difficult. Some of the most effective cross-examinations are when you get a sense of ease from them. They think you're their friend. I can tell you, workers haven't been usually examined all that frequently. So they're not, they're not that, it's not like you have like a detective in a criminal case that's been examined a million times and they're really, quite sharp. Workers tend to come in, they don't really know what they're there for, they're, sometimes they're prepped. So, a lot of times you can be effective just by getting them at a sense of ease. I'm your friend, and you lead them into a direction that you want them through that technique. Again, we've highlighted this. You don't have to get into everything in the report. You want to get into the facts that you can emphasize to prove your theory. Okay? I don't need to talk about things that aren't going to help my case. I just want to have a goal as to what I'm trying to emphasize so I can get that judge to say, this doesn't seem right. This doesn't seem right. Yes?
Whatever is going on with the phone, Lancaster can't hear you.
Sorry.
We are getting calls from Lancaster, they can't hear you.
Okay.
I understand it's the only way Lancaster's going to dissipate so they
Alright.
can hear you.
You just need to emphasize, whatever you're doing with the witness, you don't need to get all the facts of it. You don't get all the pieces of the puzzle. You get one piece. Okay? You might get another piece from a report, or you're a client. Okay? But you'll put it all together at closing. You don't have to prove everything through this one witness. You don't have to address everything through the one witness. But you have to give substantial thought as to why I'm calling this witness so that I can get the piece that I want to get. You've heard, don't ask the one question too many. Yet no one's ever told you what that question is. So I'll tell you what it is. It's when you are asking a witness who is not on your side to agree with your theory. So you ask the worker, you only met with them on 2 days, on 2 occasions, and you only sent them referrals, and you didn't do this, and you didn't do that. So you would agree that you should have done more. That question is the one question too many. See, I can argue that to the judge. You heard the worker. She only met with them on 2 occasions. She only did this. She only did that. This is not reasonable, Your Honor. They're supposed to be helping my client. But if I ask her that question, she's going to say, Mr. Steinberg, I would not agree with your theory. See, I did 27 things that you're not aware of. And you open the door to the worker having the opportunity to argue their case. That's not what we're doing, okay? You want to make your point and get out. Cross-examinations tend to go way too long because we're way focused on asking, just addressing every issue. And they tend to run on, and people lose interest, and we're not really making the points, and we're not bringing the court attention to the real issue that we want to highlight. It doesn't have to be long. It doesn't have to address every issue. It just has to hit a couple things that we're trying to emphasize, and then we get out. All right, so we're gonna show you how to lock a worker into the Title 20s.
Also, just on the last slide, the one question too many. Don't ever ask the social worker why, because you're opening yourself up for them making their case to the judge about why they're actually the sympathetic party, and they're not the bad guy in this all, and your client's the bad guy. You guys know. So don't, that's just a rule of thumb.
All right, so what this exercise that we're about to do is to kind of lock the worker into the Title 20s, which again are usually your best evidence, okay, in this case. All right, so Ms. Milo is going to play the worker, and I'll play the attorney. What's that? No, you can sit. Hi. How are you?
Good.
Ms. Milo, my understanding is you're an experienced worker. Is that correct?
That's correct.
And this case we're here today for, this isn't your only case, right?
No.
You handle a number of cases, correct?
Yes.
Would it be fair to say you handle over 20 cases?
Over 20.
Over 30?
Yes.
And Ms. Milo, you're familiar with delivered service logs, isn't that right?
I've been a social worker for 20 years. I'm familiar with them.
Okay. So each time you do something on a case, a notation is made in your logs, isn't that right?
Yes. Sometimes.
Okay. Now, Ms. Milo, it's DCFS's policy that you make notations in your logs, isn't that right?
Yes.
And you take your job seriously, isn't that right?
Very seriously.
And you take pride in your job.
Yes.
You strive to be thorough,
Yes.
and you want to be accurate, right?
Yes.
And so you know that being part of being thorough and accurate is detailing your activity in those logs, isn't that right?
Sometimes.
Okay. Well, let me ask you the question again. Are you saying that it's part of your job, or part of being thorough and accurate is not detailing your activity in those logs?
No.
Okay. And because you're an experienced worker, Ms. Milo, you would agree that your logs are complete and accurate.
To the best of my knowledge.
So, what we're trying to do is get the worker to agree with the theory that the logs are complete and accurate. Now, we're going to address in a second what happens if we get this sometimes and the answers that lead us to the court saying, well, maybe I can't rely on these Title 20s, okay? But for purposes of this activity, I can tell you from experience that more often than not, you're going to get workers that are going to say, yes, my Title 20s are complete and accurate. Okay? They're not going to usually get up there and say, oh yeah, I don't do my job right. I don't follow DCFS policy. My logs are a mess. I might do some things, I don't know. No, you're generally going to get workers. It's an easy way to establish this is the evidence, Your Honor. This is the evidence. All right. So what we're doing here is we're establishing that the only credible evidence the court can rely on is the logs. So, Ms. Milo, the case we're handling, Ms. Milo, on any given case that you handle, you meet with the child at least once per month, isn't that correct?
That's correct.
And then you note the contact that you had with the child in the delivered service logs, isn't that right?
Yes.
And you may speak with a caretaker about the child's educational issues,
Yes.
and then you put that contact in your Title 20s, isn't that right?
Most of the time, yes, I would say that's correct.
And Ms. Milo, you have contact with the parents on cases, correct?
Yes.
And then you put that contact in your delivered service logs, isn't that right?
Yes.
So, if you made referrals in a case, that would be in your logs, right?
Yes.
Now, without looking at the logs, could you tell me, you couldn't tell me the date of each face-to-face contact that you had with the child in this case, correct?
Not off the top of my head.
Okay. You have over 20 cases, isn't that right? That would be difficult to remember. Yes?
Yes.
And you would need to look at your logs in order to answer that question.
That would help.
So, what did we just do? We established in the event that we get answers that say, oh, I did all this stuff that isn't in the logs, we can argue, Your Honor, it's not credible to think that she has independent recollection of this case, of the things that she's saying she did. It's not anywhere in the logs. She told you, for example, she couldn't recall the date of each contact in this child. It's not credible to assume that she has some independent recollection of all the things that she did. In addition, she told us that she generally makes an effort for her logs to be complete and accurate. So it's imperative on the court to rely on the logs in determining whether or not the efforts of the department were reasonable. And in this case, those efforts were not reasonable because of X, Y, and Z. Okay? So what do we do next? Nothing is an option. Okay? If the logs are great and I get a worker that says they're complete and accurate, I might not do anything. Like I don't need to start asking a whole bunch of other questions. If I get the worker to say, yes, my logs are complete and accurate, and they have 3 contacts in there with nothing that has to do with anything in the reports, I can argue to the judge, Your Honor, you heard from the social worker. She said her logs are complete and accurate. This is unreasonable. Or we can go through each contact. We can say, Miss Milo, Miss Milo, isn't it true you first met with the mother on January 3rd, 2018? Isn't that right? And you gave her some referrals, isn't that right? You next met with her in April, isn't that right? Or you can go to the issue that if there's a particular issue that you think DCFS failed to assist, you can get into that. You can say, DCF, Miss Milo, you indicated that you have concerns about the father's anger issues. Yet you never recommended that the father take anger management classes, isn't that right? You didn't amend the case plan. Okay.
Okay. Jason gets to be the social worker.
Hi.
Okay. I'd like to talk to you about some concerns in this case. The report indicates DCFS feels they still haven't learned what they need to learn in order to properly raise the children. So the children were re-detained over 6 months ago, correct?
Yes,
Okay. And you made recommendations for the parents' case plan, correct?
I did.
Okay. And were those recommendations adopted by this court?
They were.
And did the parents comply with the recommendations in the case plan?
Yes.
Okay. And they completed the case plan, actually, didn't they?
They did.
Okay. But you're still putting in your withdrawn. So you didn't ever amend the case plan. You didn't ever ask the court to supplement the case plan, did you?
I didn't know I could.
You didn't ever recommend additional services, correct?
No, I could. No, I didn't.
You could have done so, correct?
I guess.
Okay, let's move on to the concerns you mentioned regarding the parents. This is, we kind of went a different direction with this. We don't really need to, I don't think, address the lesson. It might confuse some people. All right.
Yeah. So, so in this hypothetical, right? We have a parent completing a case plan, and we have a worker who is not recommending return for some reason. Okay, apparently they believe that the parent hasn't learned or that there's other issues, and so we're highlighting these things that they didn't amend the case plan. It doesn't matter if they knew they could have done so or not. Okay, if they didn't recommend additional services, like they didn't. You got to think of it as DCFS's job is to reasonably help these people, help get their kids back. That's the goal of this thing, okay? And so if they have problems that they're finding out like 6 months ago, and there's anger issues, and they're not really helping these parents identify and address the issues, we're highlighting through our questions that there was things they could have done, but they chose not to do them. Okay? And so we can argue to the court, and we can say, you heard the worker, she knew about this. She knew of these issues, but she didn't do anything about them. She didn't amend the case plan. She didn't bring it to the court's attention. She didn't file a ex parte, hey, there's some issues. She didn't do anything. She just brought it up in a 2-2 report that I got yesterday that the parent hasn't done 27 other things, or that there's anger issues that I wasn't aware of and the parent wasn't aware of until now. It's not reasonable. So think about what I can bring to the court's attention to address like the 4 things that we talked about in the beginning, which I don't have right in front of me, but are basically, that they failed to identify the problems. They failed to maintain reasonable contact or make reasonable efforts to assist the family. If we comb through the reports and we comb through the Title 20s and we're trying to pull out facts that support our theory that they haven't done one of those things, or 2, or 3, whatever. So when things go sideways, which they probably will at some point, we kind of talked about, or I kind of talked about like what I try to do in order to think about where I might get answers I didn't expect. If I think about the responses I might get, there's usually not like 30 responses. Like I don't have to think of like 30 different scenarios. It's usually like, okay, the worker might say like for instance, and the worker might say, that her logs aren't always complete and accurate or something like that, and I might have to give some substantial thought as to like how I'm really going to address that. Now, it might just be like, you understand it's DCFS's policy, and you're telling us that we can't rely on your Title 20s. How are we, I would suppose that we couldn't rely on your reports either. Like, it might be something along those lines, but I might want to give some thought as to, where I might get some answers I didn't expect. I think generally where it comes from, like most often in these cases, is when the worker starts saying like, oh yeah, I did all this stuff, and there's like 2 things in the Title 20s, and so, the best way I think to point out that it's not reasonable to rely on is 1, through the questioning that we kind of discussed before, which is that the worker can't independently recall like all these things on all these cases, but 2, it's to highlight to the court that they're not in the logs. So, if you spoke, you told us that you make a notation each time you do something on a case. And so if you spoke with the mother's therapist, that would be in the logs, correct? And are you surprised to learn that contact is not in those logs? You recall telling us that you strive to be thorough and that you strive to be accurate, and that you would agree that being part of being thorough and accurate is detailing that activity on those logs. And you recall telling us that your logs were complete and accurate. Now you're stating that's not the case, that we can't rely on what you've provided to the court. You can also talk about details, because generally they won't know details. So they'll be like, yeah, I remember, I spoke with mom's therapist. Yeah, I did that. And you're like, you told so-and-so, usually it's from the questioning of the county. Like you recall telling the county that you spoke with the therapist on this case? You couldn't tell me the exact date of that phone call, could you? You don't remember the name of the person you spoke with? You don't know the time that you called someone? And so, what you're trying to highlight is to the judge, like, hold on for 1 second. What you're trying to highlight to the judge is, not so much that it didn't happen, but that it's not, like, the best evidence in the case is the Title 20s. So, like, it's not reasonable to just take the worker's word when there's no independent verification, and they've already told us that it's difficult to recall, like, just independent facts about when things, you know, they have so many cases and what they did on each case. And so there's ways to kind of at least focus on the court on that what the worker is saying is really not credible or believable when there's no independent verification and there's information that she's already testified to. One, that they're complete and accurate, and two, that she has a difficult time recalling specific facts on the case. You kind of want to just be adaptable, flexible, and smart. Again, you're not going to solve every problem, and there's things that are going to come up, but it's not always going to be clean and easy. But your point, if you're prepared and you have a theory, you're going to be able to at least bring out facts that support your theory, even if some other facts that come out might not help your case. You know, it's not always going to be like this is just going to go exactly as planned. So try to be adaptable, try to be flexible, try to be smart, and try to emphasize and bring out the facts or through questions that support whatever you're trying to convey to the court to get them to agree with your hypothesis.
Oops, can I interrupt?
Oh, yeah.
First of all, I think you guys are doing a great job. You belong to a wonderful firm. Okay, could you, because we only have like 10 to 15 minutes left.
Yeah.
And one of the big issues I have is the 18-month, the 2-2 days, some magical cases, some magical ways to convince the court, yes, either under discretion or the other cases that are listed, that we can convince them that we can go to the 2-5 days, because I think some of our hearing officers are sort of stuck, oh, it doesn't fit, and that statute has 1,000,001 things that you have to be able to prove. Thank you.
Okay, so in your handouts, at the beginning of your handouts is the case law. So we wanted to focus this MCLE on what you guys can do to get the court to the point where your judge is going to make a no reasonable services finding. Because once you get to that point, case law is completely divided. And it's so fact specific that we felt like our efforts were better used in getting you guys to the point where, because then it's up to you. And we've attached the cases, and it's so fact specific, you have to read these cases. Because we put the pertinent part of the holding on the slides, and we put this site, and you guys can look it up, but it's so fact specific. It's so dependent on the facts of your case and the facts of the cases that we've supplied that we didn't, those are there and we can get into those, but we want to get you to the point where the judge is going to be inclined to make that no reasonable services finding to begin with. Because then it's on the attorney to say, and this is why. Now that the court has made these no reasonable services findings, this is why you can't set the 2-6.
Yeah.
Well, you
And
know,
then, let me. So there's cases and statutes that have been applied differently, and it gets confusing. Okay. It's in the handouts, and we sort of put like what the good cases are and what the bad cases are. The best way to think about it is really it's discretionary. If the court finds no reasonable services at 18 months, it's discretionary to go to the 24-month date. It can't go past the 24-month date. Okay? So you can highlight whatever arguments you want. I mean, it doesn't make sense just as a reasonable person to say, yeah, DCFS didn't do their job, but we're going to ignore that and we're just going to adopt the child. Like, you know what I mean? So I think you have to argue anything at your disposal. There's statutes that we threw in there that say that the court shall not terminate parental rights without a reasonable services finding. You can use that, but it's been applied in certain scenarios that aren't always applicable by certain cases. I don't want to get in the nitty-gritty because it really gets kind of convoluted, and it's not that helpful.
So basically, make a great record, take it up, hopefully you can get a new case that can be added.
I would say, Donna, I would disagree. I would say that the by and large, the majority of bench officers, if they find a note, if you're at the 18-month date, the true 18-month date, not like the 23.5-month date, we're talking about the 18-month date or 19-month date. If they find no reasonable services, I would say that the majority are going to give you additional time. Like, I mean, yes, there's probably some factual scenarios where they might say, yeah, it's not in the child's best interest, the parent's completely whatever. But it's a discretionary standard. There's statutes and cases that will help you craft those arguments. But I think it's rare that a court, that we put on some great reasonable services contests and the court goes, yeah, I agree, DCFS did a terrible job here. Nevertheless, we're going to set it through 6. Like, is that happening all that often? It doesn't feel like it is.
Yeah. Should go.
The judges not sometimes say, we're at the 18-month stage.
Well, then there's statutes and there's cases that say 352 is essential. I mean, 352 says the court can continue any hearing up to the 24-month date, provide family reunification services. There's cases in the slides that say that the legislature has not intended 18-month to be a hard and fast rule, that court shall consider best interest of the child. There's definitely discretion if the court wants to go up to the 24-month date.
And isn't it Alvin R, here, yeah. Yeah, Alvin R, which is on page 3, also specifically states that one of the remedies for no reasonable efforts is an additional period of time for reasonable efforts to be provided.
Right. So the court clearly has discretion. If your bench officer's not like, I don't think I can go to the 24-month date, there's plenty of cases and statutes that you can cite within the slides that will help you craft that argument. But there's definitely discretion. The court can definitely use 352. There's plenty of cases that have gone to the 24-month date under these circumstances. The real answer is they don't have to, unless if you're conducting those like, oh, this is like a 2-1F, 2-2 contest where the reasonable services portion is discussing some portion of the statutory period, meaning I was supposed to get 12 months of reasonable services, but for whatever reason the 2-1F contest came and went, and the court just like did this, dual 2-1F, 2-2 contest, so we're really discussing like the last 12 months, not really just the 12-month to the 18-month date. If the court finds that any portion of the statutory period the person getting reasonable services for, the court has to give you another 6 months. So even if the court found that, yes, one day touched the 12-month period and they didn't get reasonable services, for that I have to get another 6 months. Okay?
Is there a case in
It's in the
Pages 4
handout.
and 5.
It says it. Yes.
Slay down.
Now I got a writ attorney that's gonna.
Steve, you can't ask any questions.
Go ahead.
This was my comment. I don't think as parents' counsel, we can wait for the department to mess up. At the time of the disposition hearing, I know we get all those disposition case plans on those pre-printed forms. Those pre-printed forms are terrible. You need to develop your own case plan, which the workers are actually obligated to do within the first 30 days after detention of a child. And what you need to do is make sure that the case plan at least includes that the worker is obligated to meet with your client within a week, 2 weeks, at the DCFS office and set up the intake. You can always have a contest on what the worker does or doesn't do, because that's reasonable to do. Also, unfortunately, there is case law where just handing the client a packet of information, it also has advertisement for, accountants and apartment buildings and things that they get printed off their website to give to the client, and that's reasonable services. You have to have something in your disposition case plan that suggests that's not reasonable. You need to meet with the client and set up something. Also, just a website you all can go to and download the DCFS Welfare Policy Manual, which is found at m.hcw.gov. policy.dcfs.lacounty.gov. That will set out what the worker's responsibility is for everyone that they owe to the client, and use that as a guide when doing cross-examination. And so those are two things, but we just can't sit back and wait for a mistake.
Well, and so that kind of leads us into our last slide, and then we're going to open it up to questions from you guys, just because we're running, I know you have to get back to court. So don't forget to consider calling your client. We've talked a lot about cross. Sometimes the best person to tell the court about the lack of services is the client. I'm sure you guys have met with your clients in the hallway and they give you a very similar story that they haven't gotten in touch with the social worker, they've been calling the social worker, they've been texting the social worker, all of these things. I always tell my clients, kind of piggybacking off what Steve was saying, is keep like a log of every contact you have with DCFS. They have their Title 20s, that's got their back. Your clients need to have theirs. I tell my clients the same thing with visits. It's very important if you can get, a lot of social workers now have cell phones, they'll text clients. I always tell my clients, try and text exclusively with the social worker. Try not to talk on the phone. Every conversation they have on the phone, social worker has one version of events, our client has a completely different version of events. The best thing is if you call your client to the stand and you say, you know, I always tell my clients, if you're calling the social worker, make sure you know their email, make sure you know their cell phone so you can text them, ask them, hey, I called these programs that you gave me on this referral list. They all have a wait list. Do you have another? I mean, these are proactive things that you have to tell your client. They don't know to do these things. It's very important that you stress this to them early on so that when you get to, hopefully you're not getting to this point, but if you are getting to this point, they have something to back up what they're saying. They have text messages, you know, they text the social worker this date, social worker didn't get back to them, text the social worker this date, social worker didn't get back to them. And then the social worker text them about like a random drug test on a certain day. To show though that, and your client can testify, okay, is this the number you contact the social worker at? Are these your communications? Have you made attempts to contact the social worker regarding your inability to get enrolled in this program or that program? Like I said, just these writings corroborate your client's version of events usually, and can really cut at the credibility of the social worker who has a million cases. This is your client's life. It's very, very important, and that the court knows how serious they're taking this, that they're being proactive, that they're doing stuff, because like Steve said, they give you a packet, some courts say that's reasonable. There is a bit of unfortunately, there's a bit of an obligation on our clients to make sure that they're writing the social worker. As sad as that is, if they have a million cases, you have one case. Make sure that you're on them, okay? That's what we always should be telling our clients, I think. We have a couple minutes. Do you guys have questions? We've heard enough from you, this guy.
No, just one comment. The Title 20s that usually end up coming to us are redacted forms of the case service log. If you got the full case service log, you would have probably 5 times the number of pages or more than we usually get. What happens is that the case service log is under Title 20. Title 20, by the way, is a title under the Social Security Act. The federal government, any social worker who goes out and meets with children of the night, or goes to group homes, anything, they're required to make the service log entries in order to get federal funding under the Social Security Act. The county council has 2 or 3 people who sit and make sure that the court makes these reasonable service findings all the time, and goes back and asks for non-pro-tuncs on minute orders, because without that finding, the court loses, or the DCFS loses funding for the entirety of the case, if at one time that finding isn't made. Make sure you're not getting a redacted form of the Title 20s when you order them, that they all come to you, because what happens, the social worker will send it to the county will take out the stuff that they think is attorney-client related, and you're going to end up with those little paragraphs, I visited here and there. The entirety of the visits, the entirety of all the phone calls made are available. If you need to have the court redacted, that's the way it goes. You take your chances, since we're sort of on a linear system where one judge does the whole case, but ask for the entirety of the packet so you can really see what was going on and judge whether the worker is providing the services that you set out were demanded in the disposition case file. So in order to save a lot of these cases, like in the kinds of questioning that Jason and Christine did, you really need to have the entirety of the Title 20 packet.
Yeah, and then,
Now you're supposed to ask any questions? Guys?
Any questions?
well, no, and then also with the Title 20, workers are trained in school and at DCFS that if it's not written down, it didn't happen. So that's,
It's a good question.
it's,
Right. You're trained, you had DCFS training, they told you that if it didn't,
if it's not written, and social workers, just say, what did they tell you, and I don't know how to, what would they tell you, if it's not written, it didn't happen, they'll finish it for you. So,
any other questions? Last one.
Any suggestions for when you get a social worker on the stand who's really just digging in their heels and every single answer to your question is, I don't know or I don't remember?
Great.
Get the Title 20s
Perfect.
admitted, bye.
Yeah, that's you're their own worst enemy.
Yeah.
At that point.
The judge isn't gonna feel sympathetic to DCFS. Be done with that person. Get the Title 20s admitted, call your client, and make sure your client is prepped and ready to testify and sympathetic.
But I think the more times they say, I don't know, or I don't remember.
Judges don't like that.
The worse they look.
Right, you can argue to the court, how can you rely on this person? They don't remember anything.
Or if they come in with 3 pages for 6 months, we have one that judges.
That's even better. That's
No
great.
equal services.
You don't even have to, that's it.
Yeah.
All right, thank you.
We'll be around if you guys have questions.
Just keep it.